and that has been the reason why LSK Nairobi opted to have it broken down into different sessions, and I think this is the third session now. Today, we're just going to talk about children in conflict with the law, child offenders under the Children's Act, so that we can be able to see the new provisions, which are very, I would say, exciting. I still get excited up now when I look at the new act. Just, in recap, our first session, we talked about the new definitions that had been provided for under the Act, the upgrading of the age of responsibility and criminal responsibility for children, and very interesting facts. We talked about child support, we talked about child custody, we talked about maintenance, and we talked about adoption. So today, the focus of this conversation is just on children who are in conflict with the law and the provisions of the Children's Act with regards to that, and especially the new provisions on diversion that we previously did not have under the old regime. So I'm just going to share my screen so that we can get right into it. And then, of course, because it's a very short conversation, then we can take in questions and have a discussion and call it an event for today. Yeah, so as I said, we're talking about children who are in conflict with the law. So first and foremost, just establishing jurisdiction of the of which court tries offenses committed by a child. And under Section 217 of the Act, it provides that, notwithstanding the provisions of Part 2 of the Criminal Procedure Code, a children's court may try a child for any offense except the offense of murder. I believe the only reason, or maybe one of the major reasons why the Act is saying that, is because murder is a capital offense and tried exclusively at the High Court, as we all know about that. But I often wonder why not other capital offenses. For instance, robbery with violence also carries a sentence similar to the sentence provided for murder. But a child who has been accused of robbery with violence will still be tried for at the children's court, but a child who is accused of murder, regardless of the fact that it carries the same sentence and both of them are capital offenses, will still remain at the High Court. I believe one of the reasons for this is the Children's Court is established as a specialized court that it takes care of the interests of the child in a very unique way that maybe most other courts may not take into account. So maybe it's a conversation for future reform in terms of harmonization, to have all offenses committed by a child handled by the Children's Court, as opposed to having some cases handled by the Children's Court, others handled by the High Court. And specifically here, we're talking about murder trials. Now, we have some interesting provisions as well, which are new to the Act. For instance, under Section 218 of the Act, the police officer who has arrested a child must notify the parent or guardian and the children's department within 24 hours. Initially, under the old law, if I would use that, the repealed law, there was no direct provision mandating the police to inform parents or guardians and the children's department of any arrest. And so you would find cases where the court, a child is arrested, and I've handled some of these cases. A child, is arrested, placed in the cells, processed through the judicial process, and maybe the only time the court gets to inquire about the child, whether the child has parents or guardians, or if there's anything, would be at the moment where the child is taking a plea in court. And that's when the court would just for good practice and in the best interest of the child, inquire. But right now, a police officer must notify the parents and guardians and children's department within 24 hours. And within the same requirement under Section 218, the children's officer will then submit a report to the police, and we will look at what the nature of the report that the children officer presents. This is the first report. We'll notice that later on, there is a second report that the children officer will give to the court during the first appearance of a child in an offense who was offended the law. So here the children officer will submit a report to the police, and this is what the report says. Contains 1, a social inquiry on the child to ascertain the social, economic, personal circumstances and needs of the child. This is all happening way before plea is taken, way before maybe investigations are still going on, or they already have and the child has been arrested. So a social inquiry will need to be done and given to the police. And it's supposed to form part of the committal bundle that the police use, the police file, if I would use that as an example. Then the report will also include an explanation of the child's, whether the child has a tendency to engage in activities that are in conflict with the law. Is the child a first or a second offender or a third offender? Have they, rubbed shoulders? Have they been accused before? How has that been dealt with before? Then number 3, the surrounding facts and circumstances leading to the child's conduct in conflict with the law. Sometimes you find children getting in conflict with the law because they are maybe escaping abuse. I once had a case where a child was running away from home because of abuse. He was being constantly beaten by his stepmother. And one time, this child decides to run away. And as he's running away, the stepmother runs after the child, catches up with the child, and, has a stick and is about to beat the child again. And the child picks a stone and hits the lady with on the head. And the lady falls down. And of course, the child later on gets arrested and is charged, with assault, causing grievous harm. And at that point, being almost, as we know, the ingredients of the offense would not take into account really what were the surrounding facts and circumstances, except during mitigation, when there's a mitigation address where the child is addressing, or the parent or someone is addressing the court on a mitigation to reduce the sentence, is when the such facts and circumstances are taken into account. But currently, under this act, these facts and circumstances need to be captured in that report that is given to the police, for the sole reason of the fact that it guides the police with and the DPP on making the decision on whether or not to charge this child with the offense that he or she has been accused of. So it is a very welcome improvement and a reform in the law, especially with regards to children who are in conflict with the law. Then we have provisions for remission under section 213 of 219, sorry, of the Act, where it says subject to the rules and directions made by the CJ, which I'm hoping the CJ will make, where it appears to a court other than a children's court at any stage of the proceedings that a child is charged before it with an offense other than murder again, and is not charged together with a person or persons above the age of 18 years, the court may, and where within the area of a subordinate court's jurisdiction, there is established a children's court having jurisdiction, remit the case to a children's court. So my reading of this section 219, and on a very preliminary point, and maybe this will be cleared up with precedent in future, is that where you have a child who has been charged together with other non-children, with other adults, then they may not necessarily be able to benefit from the provisions of, from being tried in the children's court. They'll be tried in whichever court that would be, because this requirement seems to be for children who are not charged with people who are above 18 or with adults. So if a child has been accused of a crime or of offending the law, and they are with other non-children or adults, if I would use that, then they may not really benefit from such procedures in the children's court. And I'm not sure how diversionary processes will also, whether they would apply under the Act for purposes of that child. That is something I believe that we will wait to see in practice, and as the court develops its own jurisprudence in that. So otherwise, all the other matters must be remitted to the children's court to determine. The new act under section 220 provides for the right of a child to privacy. For the first time, of course, we've always known under the old act, the repealed act, that such privacy has been construed under the best interest of the child provision. But this time round, we are talking about privacy being specifically provided for under the Act for children who are in conflict with the law. Privacy during arrest, privacy during investigation, privacy at all stages of the proceedings in court. And this includes the fact that a person shall not release any information during any of the processes from arrest that may lead to the identification of the child offender. This usually, of course, prevents stigmatization of children and enables a child to go through the process and get a chance at life without carrying the stigma that comes with being processed and arraigned and arrested for such a matter. This includes the practice that DCI have. I'm sure we all know DCI love very much taking mugshots of persons who've been arrested with crimes and posting them online. So the law now prohibits that, especially with regards to children, for the reasons that I have already mentioned. Then, of course, the age of criminal responsibility under Section 221, a person under 12 years shall not be held to be criminally liable for any act or omission. And then an interesting provision here is that a child who commits an offense who's under the age of 14 years shall be presumed not capable of differentiating between right and wrong. So first of all, we get an enhancement from 8 years to 12 years. So under 12 years old, you're not criminally liable. Between 12 and 14, there's a presumption, and the thing about presumptions is they can be rebutted. So I'm foreseeing a situation where a child who is between the age of 12 and 14, who's been charged with a crime of any sort, the court might have to do a trial within a trial to establish whether or not this child can be able to differentiate between right and wrong. So as practitioners, if we find ourselves representing such minors who are in conflict with the law, would need to know that that's a rebuttable presumption, and we can prepare our clients accordingly in order to establish whether or not they can be charged for that. Then the right to fair trial specific to the child. Of course, the child is a human being just like others, and so benefits from Article 50 of the Constitution. So the right to fair trial, presumption of innocence, the right to be notified of charges preferred against him or her, and the right to legal representation. The right to the presence of a parent or guardian. This is now unique to children, and it's a new creation of this current act. It wasn't there in the old act because the old act was majorly guided by the Criminal Procedure Code and the Child Offender Rules. So a parent or guardian would have the right to be present during the trial of their child. And now I highlighted legal representation because it is now just in the same way that the murder trials, murder of capital offenses, especially murder, they have a right to legal representation by the government. The act actually provides now that the child has that right. If the child cannot be able to afford, or the child's parent can't afford to hire a lawyer for purposes of representation, then they are entitled under the Act to legal services. And this is, you can, I didn't put it in a slide, but you can read it out in Section 233 that provides the right to legal representation. In fact, Section 233 says the children's court shall, at the commencement of proceedings in court, inform the child in a language, one, the right to remain silent, the right to have a parent, guardian, or close relative, or probation officer in court. Then C, the right to legal representation, and D, the right to legal aid. So a child has a right to legal aid, And this is the point where I pause and I still make a plea to all the advocates who are attending this sensitization. Please volunteer your services at the Children's Court so that we can guarantee and enhance this children's right to legal aid for children who are in conflict with the law. Then about detention pending trial, that includes where a child has been, arrested. Under Section 223(1), institutionalization and detention of a child in conflict with the law pending a trial shall be used as a means of last resort, meaning the court must figure out every possible way, and it's only when there is no other way out that the child will now be institutionalized pending trial. And where it is as practicable as possible, that is, it should be replaced by alternative measures such as placement with a family or in an educational setting or home. So I believe the court would have to figure out, probably after the plea has been taken, if it's going through to the normal criminal process, is there a placement that the child can be put in, either with the child's family or a different family or an educational setting? And if it just can't work completely, is when the child now will be institutionalized. Okay, so under Section 224 of the Act, we have two processes that a child who is in conflict with the law will be taken through. The first is diversion, and the second is now judicial process in accordance with the Criminal Procedure Code. Diversion is a new one in our legal system, and I'm going to discuss that in a short while, because we are all familiar with the normal criminal process under the CPC. So I'll not focus so much with that, but discuss diversion in greater detail. So diversion is provided under Section 226. Now, I would just want to take time to remind us of, I think, the first session I had that defined what diversion is, and Section 2 of the Children's Act in definition says diversion means the intervention and programs designed to divert children from the criminal justice system. And then it has its various aims. Now, the objectives of diversion, well, first of all, captured under Section 2, and secondly, captured under Section 226 now of the Act. For under Section 2, the objects of diversion was included, reducing stigmatization of children who are in conflict with the law. 2, identifying children who are at risk and connecting them with support services. Then providing programs to support children who engage in offending conduct, and also reducing recidivism. Recidivism is where a child repeats the same offense that they have done, or even gets into further crime. But now under Section 226, the objects of diversion are using alternative methods to hold children to account for unlawful acts or omission. Diversion doesn't mean you just let the child go without the child facing consequences. There's been, if you look at the Hansard that Parliament and the debates that the members of Parliament were having while discussing the Children's Act, especially with regards to these provisions on diversion, there were some concerns that we are letting children go easily and a child will just commit an offense and walk scot-free. That's not what the Act is providing. It's saying the children must still be held to account for their unlawful acts or omission, but there must be a way of doing it, an alternative way, promoting rehabilitation and reintegration of the child, providing an opportunity for those who are prejudicially affected by the conduct of the child to express their views, encouraging symbolic restitution by the offending child as compensation for the harm caused. Symbolic restitution is where a child makes some kind of restitution, either through payment of fine or through doing community service, where they get it into their head that what they've done is wrong and they have to make payment for it. Promoting reconciliation by the child and the community, and minimizing stigmatization of the child. This is what diversion really is about. So this is where it gets really interesting and very important for us to take note. Who is eligible? Which child is eligible for diversion under Section 227? Eligibility, one, there is compelling evidence that the child committed the offense. I will make haste right now to say, if you have a client and your client is a child who is in conflict with the law, and you know very well that this child has not committed that offense, or maybe there is no direct, there is no direct, the evidence is unsustainable, that if you went to trial, it is possible that this child would be found not guilty, then you should not, recommend diversion at the onset. So where there is compelling evidence that the child has committed the offense, then diversion is something that needs to be considered. Then two, the child freely and voluntarily admits responsibility. So a child says, it is okay, I agree, I committed this offense, and I am sorry. Then, the child can be able to qualify for diversion. I've seen a question someone has asked what diversion is. I'll just recap and say diversion, these are processes that are geared towards removing the children from the normal criminal justice process and taking them through a different process that would enable them reintegrate with the community, accept that what they've done is a wrong thing, and get rehabilitated, for if I would be able to say that. Yeah, so the child would have to freely and voluntarily admit responsibility. The offense charged should not be a capital offense, so you cannot do diversion for capital offenses. The child's parents and guardians must be able to consent to diversion. Concerns of the victim and family must be considered, and also the diversion is available for children who are first or second offenders. Though we'll look at and see that there are 3 levels of diversion, but there are, according to Section 227, it's just seems to be available only for first and second offenders only. So this process is kind of similar to plea agreement, the process of not plea bargaining, but entering into a plea agreement. It's coming up under similar inspiration for plea agreements, but now this is specific to children who are in conflict with the law. So take note of that, then you can be able to know whether your client is eligible for diversion. So there are 3 levels of diversion, which a court is directed to, take into account. And these levels they rank from the lowest to the highest, depending on the circumstances of the case, the severity, whether the child is a first offender or a second offender. Those are the 3 levels, and you'll see the seriousness of the levels keep increasing. So I'm going to discuss level 1 under section 230, diversion under level 1. These are the options that the court has in terms of, think of it like after the child has already been, admitted to a crime, pleaded and said that they did it. So what next? The court may direct for an oral or written apology to a specified person or person. Just tell the child, can you write an apology? Can you apologize to whoever you wronged? Then a formal caution with an apology, placement under supervision or guidance not exceeding 3 months, placement under family time order not exceeding 3 months. We look at what family time orders are. Placement under a reporting order not exceeding 3 months. Reporting orders are these orders where a child has to keep reporting either to a probation officer or a children officer, maybe every week for a period of 3 months. Also prohibiting a child from visiting a particular place. This is really in the best interest of a child. I once did a trial where the child was told, you know what, before we consider all this, your parents must move from where they are, because if you go back to where you committed the offense, the community may not be very happy with you. They might take matters into their own hands. So such prohibitions, these are all level 1. And as you notice, level 1 diversions, we are talking about not exceeding 3 months, not exceeding 3 months. They are all 3 months. They're very, fast level kind of things, yeah? Then we go to level 2 diversion. So now under level 2 diversion, we have all these that we've talked about under section 230, but now where we are talking about 3 months, now for level 2, we are talking about 6 months in level 2 diversion. So oral written apology, formal caution, placement under guidance, now here it will be for 6 months, family time order 6 months, reporting order not more than 6 months, good behavior order not more than 6 months as such. But now level 2 diversion introduces vocational training for a maximum of 8 hours a week for a maximum of 6 weeks. This is to just, also in the process of rehabilitating the child. Also, we have a community service order. We have compensation to victims and families, and then referral to family group conference. Again, as I said, we'll talk about what a family group conference is. So the level 2 diversion more serious. Then we go to level 3 diversion. Now under level 3 diversion, we are talking about any of the above. So all the sentences, or I would say diversionary measures in level 1 and level 2, but now we've enhanced, the law has enhanced it to now 12 months. Then referral to residential training facility, now for 35 days in total. This is where a child now lives in a residential training facility for 35 days. And there has to be, out of these 35 days, 21 days must be consecutive. So if you notice, level 2 just talked about vocational training for 8 hours a week, maximum of 6 weeks. And now we are talking about a residential training facility where the child actually lives there, performance of some service to the community without remuneration, compulsory vocational training. So these are the 2 levels, level 1, level 2, and level 3 of diversion. So when you're getting into this process, you need to take this into account. Let's talk about what a family group conference is. I'm sure you've seen that's part of the diversional measures that the court can give or can order a family group conference. So under section 232(5), the primary function of the family group conference is to discuss the offense committed by the child in conflict with the law so that the child may understand the impact of the offense, acknowledge it, and obtain support for the reform of his or her behavior. So it's a meeting, I would say that, yeah. The child sits with some members, some people we're going to see, and they just discuss that offending conduct. As you know, so that the child can get the necessary support so that they know, you should not do this. If you do it again, this is what will happen. In that, it's called a family group conference. Who attends the FGC, the family group conference? These are the main people who are supposed to attend it. The child with his parents and guardians. 2, a children officer. 3, the probation officer. 4, the director of public prosecution. 5, victim of the alleged offense. And 6, the legal representative of the child. So they all sit. So if an FGC, a family group conference is happening every week, if the court has directed every week that you must have a family conference, these people must show up and sit down at some specified location to discuss with the child that offending conduct. The psychology is that some teaches us that when you speak to a child over and over in such a setup, it has an effect. I've seen cases where children have said that, you know what, you'd rather just beat me than even talk to me because they can get away with it. But this actually has a big impact in preventing the child from recidivism, from repeating the offense, because he or she has been spoken to over and over and over again by all these people. So lastly, before we take in questions, what happens after conviction? Now, when you read section 239, you will notice that the spirit behind the act is really, to the best possible extent, do not incarcerate a child. And I have taken time to just underline some of these things. So a child has been convicted of a crime, found guilty. So what happens? 1, discharge the child under section 35(1). This is an option that the child can, you can take into account when you're representing your client. You can say, okay, we found the child guilty, and take note that we are talking about conviction in the sense that this is now not diversion. Diversion does not lead to conviction. Diversion is the process we've talked about where it's a different process from the criminal procedure process. where the child has other remedies and other diversionary measures the court takes once the child has accepted. But here we are talking about a child has gone through the system. The court can still discharge under Section 35 of the Penal Code. I'm going to read to you what Section 35, just to remind us what that provides. Under Section 35, it provides for absolute and conditional discharge. And it says where a court by or before which a person is convicted of an offense is of an opinion having regard to circumstances, including the nature of the offense, the character of the offender, that it is inexpedient to inflict punishment, and that a probation order is also not appropriate, the court may make an order discharging him or her absolutely on condition or on condition that he commits no offense during a period not exceeding 12 months from the date of the order. So the court can say, okay, we're not even putting you on probation, we are simply discharging you, but you must stay for a period of time, 12 months, don't commit any crime, and any other conditions that the court may make. So again, limiting incarceration. Then second, discharge the child on his or her entering into recognizance with or without sureties. Thirdly, make a probation order against the offender under the Probation of Offenders Act. Then 4, commit the offender to the care of a fit person, whether a relative or not, or a charitable children's institution willing to undertake the care of the offender. As you can see, we're in option number 4, we're still not talking about incarceration. Then for a child who is between 12 and 15 years, sending the child to a rehabilitation institution with necessary conditions. Then ordering the child to pay a fine or compensation. Then for a child who has attained 16 years, referral to a Boston institution. Then placing a child under the care of a qualified psychologist or a counselor. These are very innovative sentences, I would say, under the Children's Act, taking care of that a child, the court can just say, go, we are placing you with so-and-so who's a qualified psychologist, and that would take that into account. Then placing the child in a probation hostel is also one other option amongst the many options that the court has in terms of taking into account the children. So I'll stop that sharing at that point. That's majorly the extent to which the provisions of the Children's Act with regards to children who are in conflict with the law. And the rest of the processes, the ones which you already know about under the Criminal Procedure Code, so I would not want to bore you a lot with that. And I think that's it from me. Maybe I can try answering some questions. I have seen someone. Okay. Yes, Joy.
Thank you so much, Dr. Benga, for the beautiful presentation. Very insightful indeed. So the first question that was asked has already been addressed. Someone was wondering what diversion is. I think that was more of curiosity. Then There is Jace Gedenji who asks, in a case where the family cannot afford legal representation, how can they get pro bono lawyers who are based in money and have an extension project in Gong, where it has come to our attention that children who are in conflict with the law have unfinished cases, about 20 of them. This is because there's no representation. I'm not so sure if that is directly connected to today's presentation.
Okay, I can answer that. At least as the practice is in Milimani, for the Nairobi Children's Court, and I think maybe other children's courts are catching up, but at least here, there is children, the children are provided for with legal representation. So now that we have the act that requires legal aid as a right for the child, I believe the organization can take that up and actually request for legal aid in court, and the court can actually make a direction for legal aid, either appoint an advocate who can take that matter on a pro bono basis. But for Milimani, I know at least the practice is that the children all children who are arraigned can be able to access legal aid.
Thank you for that question. A lot of other questions that are coming to me are in regard to the presentation. And sorry, I understand the streaming began late, but the recording will be uploaded on the social media page, our YouTube page. So in case you came in late or you had to leave and you want to know what has been discussed or is being discussed, the same will be available on the branch's YouTube page. So Samuel Wainaina asks, kindly elaborate what a Boston institution means.
All right, thank you. A Boston institution, actually there's an act specific that, for establishing Boston institution. It's an institution, an advanced rehabilitation center for children, yeah, where a child goes there and is offered both rehabilitation and education now, and not just education in the sense of the formal education that is required under the Basic Education Act, but also vocational training. So it's an institution that is specific with those major aims to rehabilitate the child, to provide training, vocational training and basic education, so that the child can actually be reintegrated back into the society.
I hope that's clear, Mugo Karuga. Teresa Atema says, how can a child who has no representation identify how and where they can access pro bono services? I believe that has been addressed in the previous question. So unless there's someone who hasn't had the opportunity to type in a question and they still feel they have a burning question, they can raise their hand with the feature provided. Okay, I can see the question. Let's see. Lucy Kamau. I got a friend who approached me that he was married. But okay, well, it's a bit. Okay, that's a direct message. My apologies. So I cannot see any other person. Timothy Oyo, what processes are used to determine who a fit person is? Who is a fit person before the law? That's a question by Timothy Oyo. I encourage you to type in your questions so that we take a couple of them at a go.
Mm-hmm.
Dr. Benga, That was to you. What
Okay,
processes are used to determine what a fit person
okay,
is?
I can answer that straight as we wait for any other. A fit person, that's a determination the court makes. If you're, and I'm assuming this question is in the context of one of the orders that the court can make in placing a child in the care and custody of a fit person. The court would mostly rely on children officers and social workers to determine whether this person has any, there are some parameters. For instance, can the person take good care of this child, provide the necessary care and guidance and protection and rehabilitation that the child needs? Can the person is the person who's in good standing, that has not committed any crime, and the relationship between this fit person and the child, if there's no conflict of interest. There are various factors that the court takes into account for that in determining who a fit person is. I'm seeing another question: does the Act specify a maximum duration for institutionalization of children who are in conflict with the law? So far, apart from the provisions that have seen, I don't exactly see a maximum provision. I would say that the court says that you can only institutionalize this child for this duration. Of course, by the time a child is being institutionalized, we've already finished diversionary processes, and now we've gone through the whole sentences. And lastly, you'll see that the last, under section 239, the court will now have to revert back to written law, where it says deal with the child in a other lawful manner as may be provided by any other written law. So now that is where the penal code and its sentences would now come into play. All right.
There was a hand by Caroline Mutai. If our host can unmute Caroline Mutai. Carol Mutai.
Hi, Joy. This is Caroline. Though I've already texted. I've put in the chat section. So to save you time, maybe we just go to the question. But thank you very much for the presentation.
Great, I've just seen it right now. So how can we maintain momentum to ensure that this new act does not go to sleep, quote unquote, and is implemented fully? Do you know any immediate structural or personnel adjustments in our justice system that need to be made to process children in conflict with the law? Have you observed any changes in the courts you practice in since enactment of the Act 2022? And she says, thank you for the informative presentation.
Thank you. I'll just answer that very quickly. I think the major thing that needs to be done is training and sensitization, just like the ones LSK Nairobi has been handling. We need judicial officers to also get trained on this act. We need police officers to get trained, because you can see we have provisions that deal directly with what the police are supposed to do. Probation officers, all the players in the children's justice system need to be trained. And I think that is an ongoing process and maybe needs to be done a bit more, as well as I wouldn't think that there's any structural or personnel adjustment, because all the personnel currently involved in the child justice system are still the ones who are contemplated for under the Act. So, and the last question was whether I have seen any changes ever since the Act. The Act is still new. So yes, definitely, we are already seeing changes, even in the child offender process. So hopefully, as Carol said, it will not go to sleep. We need to maintain the momentum, maintain the sensitizations on it. Okay, there's a question. What is the applicable sentence for when the children are convicted for capital offenses? The one thing the Children's Act provides is that a child shall not be sentenced to death for a capital offense. That is outrightly provided for, yeah? And there's some provision somewhere. That is section 238. Actually, 238, no court shall order the imprisonment of a child, then notwithstanding the nature of an offense punishable by death, no court shall impose the death penalty. So that already takes care of that. Yes, someone has asked a question about best interest of the child with regards to custody and maintenance that we talked about in the previous section. So maybe I would refer whoever has asked to go and check out the recording, but there are definitely guidance on that. Yeah. All right. In your opinion, are there any implementation challenges that might exist in diversion as is presented in the Children's Act? Yes, definitely. There are implementation challenges because when you look at questions like when the court if the court directs for a family group meeting, like we talked about, that requires all these people to meet. It requires a representative from the DPP, the children officer, probation officer, the child, the lawyer, the victim to meet. And we have, say, 100 children being processed every month, just out of the top of my mind. And the court makes a direction for that, for all the 100. Because of personnel challenges, maybe they'll need to recruit a couple of more people to get the DPP to sit, the representatives from the DPP to sit in all those sessions and still prosecute cases and all that. Might be a bit of a technical challenge in that, in terms of implementation, especially with regards to, the family group care order, that meeting conference that can be given. And also when we are talking about other stuff like community services, those already happening, vocational training, and all that. Now, probably the government would need to establish more vocational training centers, more rehabilitation institutions, so that all these diversionary measures can, be taken into account. But otherwise, those are the few challenges that I think I can already foresee happening. I think I've answered all the questions, unless I've missed anything.
Thank you. I think you've addressed all the questions that were raised on the chat section. And being that I cannot see any hand that is up as of now. Unless, yeah, the chats are all clear and there's no hand up. I'd like to take this beautiful opportunity to thank you, Dr. Benga, for always giving in your time to support us, capacity building, helping us understand the new act better, and in a very simple manner. Even for the non-lawyers in the forum, I'm sure they always have a better understanding once they did the sessions. So a lot of people are still asking about the recording. For those of us who joined late, the same is always uploaded later on the Nairobi branch YouTube page, and also it's running live on Facebook. Still, if you cannot access it that way, kindly reach out to the branch and the same will be passed over to you. The same can be shared with you. So without further ado, I'd like to thank you once again and to wish you a blessed afternoon. Asanteni sana.